The Senate will come to order. The Secretary will call the roll.
Senator Buck. Senator Cannizzaro. Senator Daley. Senator Degniate. Senator Dondera-Loop. Senator Flores. Senator Goycochea. Senator Hammond. Senator Hansen. Senator Harris. Senator Krasner. Senator Lang. Senator Neal. Senator Wynn. Senator Orenshaw. Senator Pizzina. Senator Scheibel. Senator Seavers-Gansert. Senator Spearman. Senator Stone. Senator Titus.
Senator Cannizzaro.
Thank you, Mr. President. Please mark Senator Hammond excused, and please mark Senator Scheibel present once she arrives at the chamber.
Okay, let the record reflect there are 19 senators present. Please rise for the prayer by Senator Spearman and remain standing for the Pledge of Allegiance.
Let us pray. As we begin to take steps towards our purpose, we ask that you give us wisdom. As your word promises us, we ask in faith that you will give us wisdom and direction in every small and large decision. As we step into our purpose, we thank you that we don't have to rely on our own understanding, as we know that your wisdom will guide us to our exact purpose. Thank you, God, that we can come to the throne and ask anything. We ask for your guidance, and we thank you for the gift and power of your Spirit. It is in your holy name. Amen, shalom, and ashe.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Order of Business 3, reading and approval of the journal. By previous order of the Senate, the reading of the journal is dispensed with, and the President and Secretary are authorized to make necessary corrections and additions. Order of Business 4, reports of committees.
Mr. President, your Committee on Finance, to which was re-referred Senate Bill number 387, has had the same under consideration and begs leave to report the same back with the recommendation do pass. Also, your Committee on Finance, to which was re-referred Senate Bill 274, has had the same under consideration and begs leave to report the same back with the recommendation amend and do pass as amended. Signed, Senator Dondera-Loop, Chair. End of reports.
Order of Business 6, messages from the Assembly.
Assembly Chamber, Carson City, May 25th, 2023. To the Honorable the Senate, I have the honor to inform your honorable body that the Assembly on this day passed Assembly Bills numbers 62 and 448 and Senate Bill number 302. Also, I have the honor to inform your honorable body that the Assembly on this day passed as amended Assembly Bill 112. Also, I have the honor to inform your honorable body that the Assembly amended and on this day passed as amended Senate Bill 109 with Amendment 646, Senate Bill 146 with Amendment 647, Senate Bill 192 with Amendment 716, Senate Bill 235 with Amendment 658, Senate Bill 269 with Amendment 667, Senate Bill 280 with Amendment 651, Senate Bill 314 with Amendment 597, Senate Bill 391 with Amendment 705, and respectfully request your honorable body to concur in said amendments. Signed, Carol Ayala-Sala, Assistant Chief Clerk of the Assembly. End of messages.
Order of Business 8, waivers and exemptions.
We have no waivers or exemptions at this time.
Order of Business 9, motions, resolutions, and notices. Senator Cannizzaro.
Thank you, Mr. President. I move that the news media personnel noted on the list at your desks be accepted and accredited as members of the press. They be allowed to use the appropriate media space and facilities in the legislative building.
Heard the motion. All those in favor signify by saying aye. Opposed, nay. Motion carries. Senator Cannizzaro.
Thank you, Mr. President. I move that Assembly Joint Resolutions numbers 1, 5, and 1 of the 81st session and Assembly Concurrent Resolution number 5 be taken from their positions on the resolution file and placed on the resolution file on the next agenda.
You've heard the motion. All those in favor signify by saying aye. Opposed, nay. Motion carries. Senator Cannizzaro.
Thank you, Mr. President. I move that Assembly Bills numbers 33, 55, 75, 86, 91, 97, 107, 120, 124, 143, 159, 175, 177, 183, 188, 191, 220, 250, 275, 284, 285, 309, 334, 339, 342, 356, 392, 405, 408, 423, 432, 444, and 465 be taken from their positions on general file and placed on general file on the next agenda.
You've heard the motion. All those in favor signify by saying aye. Opposed, nay. Motion carries. Senator Cannizzaro.
Thank you, Mr. President. I move that Assembly Bills numbers 32 and 521 be taken from their positions on general file and placed on the Secretary's desk for the purposes of further discussion.
You've heard the motion. All those in favor signify by saying aye. Opposed, nay. Motion carries. Senator Cannizzaro.
Thank you, Mr. President. I move that Assembly Bills numbers 520 and 522 be taken from their positions on general file and placed at the top of general file on the first agenda.
You've heard the motion. All those in favor signify by saying aye. Opposed, nay. Motion carries.
That concludes Order of Business 9.
Order of Business 10, introduction, first reading, and reference.
Assembly Bill 62, introduced by the Assembly Committee on Revenue, revises provisions governing property tax exemptions for low-income housing. End of bill.
Senator Lang.
I move that we refer AB 62 to the Committee on Revenue and Economic Development.
If there are no objections, so ordered.
Assembly Bill 112, introduced by the Assembly Committee on Growth and Infrastructure, establishes provisions relating to wildlife crossings. End of bill.
Senator Lang.
Thank you, Mr. President. I move that we refer AB 112 to the Committee on Growth and Infrastructure.
If there are no objections, so ordered.
Assembly Bill 448, introduced by Assemblyman Yeager and Howdigi, revises provisions governing the real property transfer tax. End of bill.
Senator Lang.
Thank you, Mr. President. I move that we refer AB 448 to the Committee on Revenue and Economic Development.
If there are no objections, so ordered.
That concludes Order of Business 10.
Order of Business 13, general file.
Mr. President, may we get a brief recess?
Okay, we are in recess. Senate is back in order. We are on order business 13, general file.
Assembly Bill 520, introduced by the Assembly Committee on Ways and Means, makes various changes regarding state financial administration and makes appropriations for the support of the civil government of the state. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1 into Section 1.
Are there any amendments?
There are none. Section 93, end of subsection 5, end of bill.
Senator Harris.
Thank you, Mr. President. The general fund appropriations included in the General Appropriations Act total $3,453,793,513 in fiscal year 2024 and $3,588,282,593 in fiscal year 2025, or $7.04 billion over the 23-25 biennium, an increase of approximately $1.026 billion when compared to general fund appropriations approved by the 21 legislature for the 2021-23 biennium. The act includes highway fund appropriations totaling $167,536,452 in fiscal year 24 and $168,606,045 in fiscal year 25, or $336.1 million over the 2023-2025 biennium, an increase of approximately $30.8 million from the previous biennium. The executive budget included $23.3 million in court administrative assessment revenue over the 23-25 biennium. In closing the budgets for the Judicial Department, the Money Committee has approved replacing all court administrative assessment revenue and Judicial Department budgets with direct general fund appropriations. Through the replacement of that revenue source, the Money Committee's approved total general fund appropriations of $5.7 million over the 23-25 biennium to fund 30 new positions for the Judicial Department, and also approved the consolidation of all non-elected positions within the Judicial Department, excluding the Commission on Judicial Discipline, into one new budget account, and to allow the Supreme Court to employ such persons as it deems necessary with salaries and benefits determined by the Supreme Court within the limits of legislative appropriations for that purpose. The Money Committee has approved one-time general fund appropriations of $2.4 million over the 23-25 biennium to fund the replacement of the Supreme Court's legacy case management system for the appellate court, $1.3 million over the 23-25 biennium to implement a statewide digital evidence management system, and $1.4 million in fiscal year 24 to build a hybrid training facility within existing space in the Carson City Supreme Court building. Funding for public schools and K-12 education was considered separately in the K-12 education funding bill, which contains funding for the pupil-centered funding plan and other programs related to K-12 education, including the Department of Education budgets. The Money Committee's approved general fund appropriations totaling $119.1 million over the 23-25 biennium, which includes $34.5 million to fund the administration of statewide assessments. The Money Committee's approved total general fund appropriations of $22.3 million in fiscal year 24 and $24.8 million in fiscal year 25 for subgrants to entities participating in the state pre-K program. General fund appropriations of $1 million over the 23-25 biennium for a new school improvement program for Nevada's lowest performing schools, and general fund appropriations of $2.7 million over the 23-25 biennium to fund 11.5 new positions, as well as 4 positions previously funded with federal funding. In closing the budgets for the Nevada system of higher education, the Money Committee has approved total general fund appropriations of $1.467 billion over the 23-25 biennium. In approving the NSHE budgets, the Money Committee has approved to suspend the funding formula distributions component and allocate general fund appropriations to each of the instructional institutions using the traditional base maintenance and enhancement decisions unit model. In closing the Aging and Disability Services Division budgets, the Money Committees approved general fund appropriations totaling $514.4 million over the 23-25 biennium. Of that amount, the Money Committees approved general fund appropriations of $46.8 million over the 23-25 biennium to support caseload growth, waitlist reductions, and associated staffing adjustments for various programs. In closing the budget within the Division of Healthcare Financing and Policy, the Money Committees approved general fund appropriations totaling $2.514 billion over the 23-25 biennium. The funding supports projected Medicaid average monthly caseload of approximately 877,000 in fiscal year 24 and 858,000 in fiscal year 25, and projected checkup average monthly caseload of approximately 23,400 in fiscal year 24 and 23,000 in fiscal year 25. In closing the budget for the Division of Public and Behavioral Health, the Money Committees approved the general fund appropriations of $344.4 million over the 23-25 biennium. The Money Committees approved total general fund appropriations of $222.4 million to the Division of Welfare and Supportive Services for the 23-25 biennium, including general fund appropriations of $49.2 million over the biennium to the Temporary Assistance for Needy Families budget, primarily to support the TANF cash assistance caseload. The Money Committees approved $352.9 million in general fund appropriations over the 23-25 biennium for the support of the Division of Child and Family Services, including $4.9 million in general fund appropriations to transfer in 22 positions from the Northern Nevada Child and Adolescent Services Services budget and to fund 56 new positions over the 23-25 biennium to staff the Desert Willow Treatment Center. And closing the budget for the Department of Corrections, the Money Committees approved $647.9 million in general fund appropriations over the 23-25 biennium, which would provide housing for an average of 10,223 offenders in fiscal year 24 and 10,480 offenders in fiscal year 25. The Money Committees approved highway fund appropriations of $164.7 million over the 23-25 biennium to support the operations of the Department of Motor Vehicles. Included in this amount are highway fund appropriations totaling $73 million over the 23-25 biennium to continue the department transformation effort. In closing the budgets for the Department of Public Safety, the Money Committees approved $143.8 million in general fund appropriations and $161.8 million in highway fund appropriations over the 23-25 biennium. In closing the budgets for the Division of Parole and Probation, the Money Committees approved $115.2 million in general fund appropriations to support the division of the 23-25 biennium. In closing Department of Conservation and Natural Resources budget, the Money Committees approved general fund appropriations totaling $89.9 million over the 23-25 biennium. In closing the Public Employees Benefit Program budgets for the 23-25 biennium, the Money Committees approved general fund appropriations of $9.8 million in fiscal year 24 and $10 million in fiscal year 25 to provide additional annual health savings account and health reimbursement arrangement contributions between $300 and $500 based on the participants' coverage tier. The Money Committees also approved general fund appropriations of $2 million in each year of the 23-25 biennium that, when combined with the funding provided through the plan, and these appropriations would provide active state employees and retired state employees with life insurance coverage equivalent to pre-COVID 2019 pandemic levels.
Are there any remarks from the floor? Senator Severs-Gansert.
Thank you, Mr. President. Today, I deliver a message to the majority. I rise in opposition to AB 520. The governor is asking for what Nevadans want. I've been here before in another time in another administration. Political blockades do not always have good outcomes. I understand negotiation tactics and bargaining strategies have a place, but ultimately, to put the people's interests ahead of politics is the right thing to do. My words may fall on some deaf ears, but I'm hoping enough are listening. We are in a place where we've been, where we have to think about the future, not just the present game of tag. Given where we are today, searching for compromise is always better than not talking at all. I've been in a similar situation before, sitting across the courtyard. Experience is valuable here. I implore the majority to embrace what we have in common. Embrace what we have in common and work to iron out the differences. This is a time for leadership. The governor's goals are the people's goals. They're Nevadans' goals and have not been adequately addressed. Now is the time to find a healthy compromise. Last election, the people spoke. They wanted balanced government in Carson City. Where we are today is nowhere near balanced. As the minority, we are painted into the corner because of the lack of communication and acknowledgement of this Republican governor's top priorities, which are the people's priorities. Speaking from experience, from this point forward, we can and we must find that common place, that central ground to restore balance and deliver the voters what they asked for. Thank you, Mr. President.
Senator Stone.
Thank you, Mr. President and colleagues. First of all, I want to thank all the members of the Finance Committee for the countless hours that they have put in trying to balance the priorities of the state and moving the state forward. But with only 12 days to go, there doesn't seem to be a recognition that in addition to having a strongly Democratic legislature, that we do have a Republican governor. And it's important that we all step up to the plate on behalf of 3.2 million people that expect us in 120 days to get the job done. They don't expect us to act like they do in Washington, D.C. and have stalemates and don't get things done and want media attention. We've seen the contentiousness of the Senate versus the Assembly and killing great bills because of personality disputes, policy disputes. We were elected to act as mature adults, to step up to the plate, to compromise where we can. We win some, we lose some, but the best kind of government is a balanced government, and that's what we have right now. We have 12 days to go. Right now, I feel like we're in a stalemate. And a stalemate to me is not progress, but it's failure. So, my friends, Republicans are going to vote no on this budget because we have a governor that has not had his voice being heard, his priorities being addressed. Everyone, whether you're in the majority or the minority, at least deserves a hearing. We all have the power to vote yes or no and kill a bill, but why not let 63 people have a voice? Why not let our governor, who's an equal branch of government, have a voice in the process? 3.2 million people are depending on us to take time away from our lives, away from our businesses, away from our families, to make sacrifices on their behalf. And we're playing all of these political games and shenanigans. It's embarrassing. We can do better. I know we can do better. I have confidence that we can do better. And I'll close with a quote from a wise person who said, "Learn the wisdom of compromise, for it's better to bend a little than to break." Thank you.
Senator Cannizzaro.
Thank you, Mr. President. I rise in strong support of Assembly Bill 520. As my colleague did a beautiful job from Senate District 11 walking us through some very intricate details that are contained within Assembly Bill 520. What I would like to note is that this is a bill that does some of the following pieces, and I want to highlight those pieces for the body. First of all, it funds the Judicial Department. The Judicial Department, as everyone knows, operates the courts in this state. It ensures that we have the type of access to justice that is required in our Constitution. And it does so in a way that allows for our courts to operate to make sure that that balance in our court system is there. Those budgets were vetted by the money committees, both in subcommittee and in full committee. Questions were asked, and this all stems from governor's recommendation in the budget. And those recommendations were largely accepted. We heard from the Supreme Court multiple times about ways in which they wanted to operate more efficiently, in ways that they wanted to modernize the ways in which they were working on the court, and how it is that they are able to deliver that service to our constituents, to people who are looking to have access to the courtroom, which is a fundamental and essential constitutional principle in our nation and in our state. Those budgets were largely, if not completely, unanimous in the subcommittee. Largely, if not completely, unanimous in the full committee. This particular bill also funds things like the Department of Health and Human Services, medical care for our constituents, making sure that there is access to that, making sure that they can seek the care that is necessary for them. You know, one of the pieces that's in here, and I think I would be remiss to not point out, is that there was a recommendation, right, by the governor's office to increase the poverty level for women who are seeking pre- and postnatal care. That was something that we funded, that we approved in the last session that was not funded, that we funded. Those budgets, again, came from governor's recommendations, were largely unanimous, if not completely unanimous, in many of them in both the subcommittee and the full committee. Robust discussions were had, questions were asked, departments were there. We took issue with some things that we had heard. We tried to fix them where we could, and we came to, like I mentioned, a largely consensual budgetary item in the funding through our Department of Health and Human Services, which provide a variety of pieces to our constituents, not just medical care and access to things like doctors and physicians and pre- and postnatal care, but things like our children in the Department of Child and Family Services, kids who are depending on us to make sure that they are safe, kids who are depending on us to make sure that they have access to services that they desperately need, that they do not get at home. kids who are in foster care, kids who are sitting, babies who are sitting in child haven down in Clark County who are asking for this body to make sure that they have a chance. Those were not contested, wildly partisan votes. And they came from the governor's recommendation that made its way over here to the legislative body, which, by the way, we have a duty to hear and to vet. Not to agree with, not to rubber stamp, not to just pass, but to hear and vet. And that happened. If you have any questions about it, all of that is available on Nellis. You can watch all of the hearings, many of which went long and resulted those of us on the floor being later than 11 a.m. because we were having those robust discussions and asking those questions. This funds the Department of Corrections, the Department of Motor Vehicles. I mean, these are services, right, that people have, our constituents rely on, that we have to fund. That's what's in this bill. The Department of Corrections, right, being able to provide those services when someone has been incarcerated or has to go through the criminal justice system to make sure that they have the resources to handle that. As a former prosecutor for over a decade who handled very serious gang and violent cases, I hope and I'm excited that we're able to actually fund some things in the Department of Corrections so that dangerous offenders are not on our streets and that the people who are working in the Department of Corrections are safe. There's a lot in there. Department of Public Safety, Parole and Probation. These are people who are supervising offenders in our communities. We want them to be able to do that effectively to maintain public safety. We should be supporting the officers who do those jobs and the jobs that they do. Department of Conservation and Natural Resources. We know that Nevada is one of the best places to live, not only because I have a particular bias for my home state, but because there's a lot of outdoor recreation that comes along with it that supports tourism and the economy in our state. Allows us to maintain the state that we live in, the state that we all call home, the state that our constituents call home, and public employees benefits program pieces. Those public employees that keep us operating every single day. Now, what you haven't heard in this particular bill is some of the things that have been referenced on this floor in support for folks to vote in opposition. This bill is largely bipartisan, comes from governor's recommendation, and frankly, I think there may have been one or two votes that there was maybe one or two of us that voted no on in subcommittee and in full committee. Most of the people here on this floor voted for all of these things that are contained in this bill in a bipartisan fashion, after a lot of discussion, after lengthy hearings, and after receiving a recommendation from the governor. That is the job of this legislature. The job of this legislature is not to come in here and simply rubber stamp something because someone has asked us to do that. That does not happen on member bills. It does not happen on agency bills. It does not happen for any person who might be advocating for a particular policy in this building. If that were the case, then every vote on this floor would be 21-0, and we would just simply pass things as they come into this building, and we would be passing whatever we're at now, over 1,000 bills between the houses. That's not what the legislative body is tasked with doing. That is not what happens in this building. What happens in this building are proposals that sometimes we hear, sometimes we don't. Sometimes we agree on, sometimes we don't. Not everything is contained in one bill, ever. That's why we have, well, this is 520 on the assembly side. So the idea that somehow anyone is entitled to walk into this building and tell the legislature, which is a co-equal branch, separate branch of government, that we must do things in a particular fashion, ignores the Constitution, ignores the duty of this body, ignores the individuals who have voted for 21 different representatives to bring 21 different ideas to the table to be able to have discussions. And what I think is important to note is that the pieces of actual things that we are voting on in Assembly Bill 520 were proposals that came from the governor's office that were largely accepted, that where there were things that were not accepted were completely vetted at length, in depth, by the members of the money committees on both sides of this building, the Senate and the Assembly. That this particular bill contains all of the decisions that many people sitting on this floor and across the way in the Assembly chamber agreed on during those hearings, with bipartisan, often unanimous support to fund very basic governmental functions that our constituents are asking us to do, that we have a duty to do. So to hold something like kids in foster care, highway patrol, judges, access to justice, welfare and supportive services, Medicaid coverage, hostage because other things didn't happen, is a disservice to the people of the state of Nevada. What this budget represents is a significant investment in our constituents and the services of government that, again, was largely agreed on with maybe 1 or 2 votes by 1 or 2 people who did not agree with very small particular things. That's consensus building. That's bipartisanship. That's the job of this legislature. I would implore my colleagues to take a look at the vote that is going to take place, to not hold these services hostage because there are other things that have nothing to do with this bill, and to vote yes. Thank you, Mr. President.
Any further remarks? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 13, the noes are 7. AB 520 has received a constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 522, introduced by the Assembly Committee on Ways and Means, revises its provisions relating to the compensation of state employees, the people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1 into Section 1.
Are there any amendments?
There are none. Section 45 into subsection 2 into bill.
Senator Dondero Loop.
Thank you very much, Mr. President. Assembly Bill 522 establishes the maximum allowable salaries for certain employees not in the classified service of the state. This bill also makes general fund appropriations of $629.8 million and highway fund appropriations of $56.4 million for salary increases for non-classified, classified, and unclassified state employees, various grade increases for certain employees, incentive bonuses of personnel employed on certain dates, and the restoration of longevity pay for the personnel in the executive, legislative, and judicial departments, with the addition of professional personnel employed by the Nevada System of Higher Education. For state personnel not within a bargaining unit pursuant to NRS 288.515, the legislative department, the judicial department, and the following collective bargaining units as defined in NRS 288.515, the bill provides funding for a 12% salary increase for fiscal year 24, effective July 1st, 2023, and a 4% salary increase for fiscal year 2025, effective July 1st, 2024. Unit B, administrative and clerical employees. Unit C, technical aids to professional employees. Unit D, professional employees who do not provide health care. Unit J, supervisory employees from all occupational groups. For state employees organized in the following collective bargaining units as defined in NRS 288.515, the bill also includes funding for a 13% salary increase for fiscal year 2024, effective July 1st, 2023, and a 4% salary increase for fiscal year 2025, effective July 1st, 2024. Unit A, labor, maintenance, custodial, and institutional employees. Unit E, professional employees who provide health care. Unit F, employees other than professional employees who provide health care and personal care. Unit G, Category 1 peace officers. Unit I, Category 3, peace officers. For state employees organized in the following collective bargaining units as defined in NRS 288.515, the bill includes funding for a 10% salary increase for fiscal year 2024, effective July 1st, 2023, and a 4% salary increase for fiscal year 2025, effective July 1st, 2024. Unit H, Category 2, peace officers, and Unit K, firefighters. In addition, the bill provides an additional 7% salary increase for classified, non-classified, and unclassified state employees and classified and professional employees of the Nevada System of Higher Education in fiscal year 2025 if Assembly Bill 498 of the 2023 legislative session is not enacted by the legislative and approved by the governor. Pay grade increases include this bill appropriates general funds of $40.6 million and highway funds of $9.4 million of 1, 2, and 3 grade pay increases for certain positions on the classified employee compensation plan. This bill also appropriates $21.9 million in general funds in each year of the 23-25 biennium for retention incentives of $250 per quarter for the employees of the Executive Department, Judicial Department, and the Legislative Department, and the Public Employees Retirement System. Additionally, the bill allocates $3.5 million in each year of the 23-25 biennium for retention incentives for professional employees in the Nevada System of Higher Education. This bill also amends Chapter 284 of the NRS to include a plan to encourage continuity of service by providing a semi-annual payment of $100 to an employee with 8 years of continuous service with an annual increase of $25 in the semi-annual payment for an employment with 9 through 14 years of continuous service, $50 for an employee with 15 through 24 years of continuous service, and $75 for an additional year of continuous service after 24 years, up to a maximum payment of 30 years of continuous state service. This bill further appropriates general funds totaling $6.1 million in each year of the 23-25 biennium, and highway funds totaling $1.3 million in fiscal year 24 and $1.5 million in fiscal year 25 to fund the plan to encourage continuity of service. Assembly Bill 522 authorizes the Department of Health and Human Services and the Department of Corrections to provide callback pay for unclassified medical positions and pharmacists to perform on-call responsibilities to ensure 24-hour coverage in psychiatric and medical facilities. This bill authorizes the Gaming Control Board to continue the credential pay plan, which provides up to $5,000 annually for an unclassified employee who possess a current Nevada Certified Public Accountant certificate, a license to practice law, or are in a qualifying position as an electronic laboratory engineer and possess a Bachelor of Science or higher degree in engineering, electronic engineering, or computer science. Sections 1 to 12 inclusive, sections 21 to 38 inclusive, and sections 41 to 44 inclusive of this act become effective on July 1st, 2023. Sections 13 to 20 inclusive, and sections 39 and 40 of this act become effective on July 1st, 2023, if and only Assembly Bill 498 of the 82nd legislative session is not enacted by the legislature and approved by the governor.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 13, the noes are 7. AB 522 has received a constitutional majority, is declared passed and ordered to the Assembly.
Mr. President,
Yes.
we have order of business number 9.
Okay, we are on order of business 9.
Thank you, Mr. President. I would move that we suspend all necessary rules and immediately transmit Assembly Bills numbers 520 and 522 to the Assembly.
Okay. All right. I've heard the motion. All those in favor signify by saying aye. Aye. Opposed, nay. Motion carries.
Senate Bill 281, introduced by Senator Wynn, revises provisions governing public utilities. People of the state of Nevada represented in Senate and Assembly to enact as follows, Section 1 into Section 1.
Are there any amendments?
Amendment number 744, proposed by Senator Wynn.
Senator Wynn.
Thank you, Mr. President. I move to dispense with the reading of the amendment.
If there are no objections, so ordered. Senator Wynn.
Thank you, Mr. President. I move to adopt the amendment.
You've heard the motion. Senator Wynn.
The amendment changes the cost of more than $10 million in Section 10, and it removes that actual number and puts it in the power of the commission pursuant to rulemaking in subsection 3 of NRS 704.991 to establish that cost threshold.
Okay, are there any remarks? Are there any remarks from the floor? Seeing none, all those in favor signify by saying aye. Aye. Opposed, nay. Motion carries. We will now move to the final action on SB 281.
Senate Bill 281, introduced by Senator Wynn, revises provisions governing public utilities. The people of the state of Nevada, represented in Senate Assembly, do enact as follows: Section 1 into Section 1.
Are there any amendments?
There are none. Section 19 into subsection 2 and a bill.
Senator Wynn.
Thank you, Mr. President. Senate Bill 281 makes various changes to requirements for natural gas utilities in Nevada. It replaces the annual informational report with a triennial requirement for public utilities that sell natural gas to 10 or more customers to file a plan with the Public Utilities Commission, otherwise known as the PUC, and requires the public utilities to meet with various stakeholders as well as hold public meetings prior to adopting such plan. This act also prohibits a natural gas utility from filing a general rate application within 180 days before or after a filing of a plan, and requires the PUC to adopt regulations authorizing utilities to include proposals for infrastructure expansion consistent with economic development in their plans, and eliminates the requirement for the PUC to establish regulations that remove financial disincentives for energy conservation by natural gas utilities. Senate Bill 281 as amended becomes effective upon passage and approval for the purposes of adopting any regulations and performing any other administrative tasks, and on January 1, 2024 for all other purposes.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 20, the noes are 0. SB 281 has received a constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 11, introduced by the Assembly Committee on Health and Human Services, revises provisions governing hospitals. The people of the state of Nevada, represented in Senate Assembly, do enact as follows: Section 1 into Section 1.
Are there any amendments?
There are none. Section 10, this act becomes effective upon passage and approval and a bill.
Senator Donate.
Thank you, Mr. President. Assembly Bill 11 prohibits hospitals and psychiatric hospitals from employing certain physicians for practicing medicine except where expressly authorized by law. Hospitals violating these provisions may have their license suspended or revoked and are subject to certain administrative penalties. The bill exempts hospitals and psychiatric hospitals that employ physicians who are participating in specific graduate programs and medical facilities that are owned or operated by the state government. Further, this bill prohibits in contracts with or taking any action against providers who discuss with others their salary, wages, or working conditions, and from entering into non-compete agreements with providers that prohibit them from providing medical services for other medical facilities.
Are there any remarks from the floor? Senator Titus.
Thank you, Mr. Chair. I rise in strong opposition of AB 11. Although well-intended, AB 11 will do just the opposite. It will decrease access to care in all Nevada. Hospitals employ physicians frequently because they are of a unique specialty, and they're the only type of a doc that cannot come and set up a practice by themselves. So to get them to Nevada, they have to be employed. During the testimony, we heard frequently that families didn't want to go to Stanford. They didn't want to go to California to seek medical care. But yet at the very time, we're passing a bill that will force them to do just that. If the hospitals can't employ these docs, they will not come to Nevada. And yet, again, we will be forced to seek medical care outside this, this great state that we have. I urge my colleagues to please vote no on AB 11. Thank you.
Any further remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 13, the noes are 7. AB 11 has received a constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 39, introduced by the Assembly Committee on Commerce and Labor, revises provisions relating to contracts for work concerning certain residential improvements. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 3 into subsection 6 into bill.
Senator Scheibel.
Thank you, Mr. President. Assembly Bill 39 authorizes the State Contractors Board to adopt regulations establishing certain requirements pertaining to contracts used by a residential contractor and the owner of a completed single-family residence who occupies the single-family residence for any construction, remodeling, repair, or improvement performed by a residential contractor to the single-family residence or any activity for the supervision of such work. The measure also sets forth certain information that must be included in such a contract with certain exemptions. If a contract between a residential contractor and an owner does not include the required information, excluding details about an initial down payment or deposit, the owner is authorized to modify the contract to comply with the regulation. Such modification, if reasonable, is enforceable against the contractor. The measure makes the contract voidable by the owner if the contract omits information regarding the initial down payment or deposit. A contractor's failure to comply with the requirements for contracts for work concerning a residential improvement or regulations adopted by the board is subject to disciplinary action.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 20, the noes are 0. AB 39 has received a constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 44, introduced by the Assembly Committee on Government Affairs, revises provisions relating to services for veterans. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 3, this act becomes effective on July 1, 2023, into bill.
Senator Gokachia.
Thank you, Mr. President. Assembly Bill 44 revises the titles of the Deputy Directors of the Department of Veteran Services and certain duties of the Director of the Department. The measure requires the Director to provide quarterly training to veteran service officers employed by the Department and to additionally offer training to representatives of veteran service organizations who are accredited by the United States Department of Veterans Affairs located in this state. Effective date, July 1st, 2023. Thank you.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 20, the noes are 0. AB 44 has received the constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 49, introduced by the Assembly Committee on Judiciary, revises provisions relating to criminal procedure. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 27 and to subsection 2 into bill.
Senator Wynn.
Thank you, Mr. President. Assembly Bill 49 prescribes separate and distinct forms for a petition for writ of habeas corpus that challenges the computation of time that a person has served pursuant to a judgment of conviction, and a petition for a writ of habeas corpus that challenges the validity of a judgment of conviction or sentence. A person who has filed a petition challenging a judgment of conviction or sentence must not be released upon his or her own recognizance or admitted to bail pending a review of the petition. The bill also repeals the requirement that the respondent file a return with the court and instead requires that the response or answer filed by the court include the information contained in the return under existing law. A petitioner is authorized under certain circumstances to file and serve a petition by electronic means. Finally, the bill makes the amending provisions applicable to post-conviction petitions for writ of habeas corpus filed on or after July 1st, 2023.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 20, the noes are 0. AB 49 has received a constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 57, introduced by the Assembly Committee on Growth and Infrastructure, revises various provisions relating to motor vehicles. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 8, this act becomes effective on July 1, 2023, and a bill.
Senator Pizzina.
Thank you, Mr. President. Assembly Bill 57 provides that if a person is unable to sell a vehicle with a lien at a public auction after a reasonable effort, the person may satisfy the lien by selling the vehicle by private sale directly to a third-party purchaser in an arm's-length transaction. The bill also removes the requirement that a sale must be held at or near the place where the lien was acquired. Further, AB 57 revises provisions relating to automobile wreckers and the towing of abandoned vehicles. The bill revises the Department of Motor Vehicles reporting requirement concerning garages, garage operators, and body shops. Lastly, the bill repeals the authority for the issuance of a special license plate to an honorary consul of a foreign country, thereby terminating the production and distribution of such plates. And the bill is effective July 1, 2023.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 20, the noes are 0. AB 57 has received a constitutional majority, is declared passed, and ordered to the Assembly.
Assembly Bill 65, introduced by the Assembly Committee on Education, revises provisions relating to education. The people of the state of Nevada, represented in the Senate Assembly, do enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 16, end of subsection 2, end of bill.
Senator Donate.
Thank you, Mr. President. Assembly Bill 65 revises definition of bullying and certain requirements for investigating and reporting certain instances of bullying, cyberbullying, and discrimination based on race. Furthermore, the bill requires the superintendent of public instruction of NDE rather than the State Board of Education to approve work-based learning programs. The bill makes changes relating to the admittance into certain grades and compulsory education, including that the child may be required to be 5 years of age or 6 years of age on or before August 1st preceding the school year in order to be admitted to kindergarten or first grade as applicable. Additionally, AB 65 prohibits the Board of Trustees of a school district from taking any action in a regular or special meeting after 11:59 p.m.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 15, the noes are 5. AB 65 has received a constitutional majority, is declared passed, and ordered to the Assembly.
Assembly Bill 74, introduced by the Assembly Committee on Education, revises provisions relating to
Can we
agreements.
get a 1 minute recess, please?
Okay, we will take a 1-minute recess.
Waiting on it.
Okay, we are back from recess.
Mr. President, may we go to order of business number 9?
We are now on order of business 9.
Thank you, Mr. President. I move that we take Assembly Bill 74 from its place on general file and place it on general file for the next agenda.
Okay, you've heard the motion. All those in favor signify by saying aye. Opposed, nay. Motion carries. We are now back on general file, order of business 13.
Assembly Bill 114, introduced by Assemblywoman Thomas and Senator Wynn, revises provisions governing the Nevada Early Childhood Advisory Council. The people of the state of Nevada, represented in Senate Assembly, do enact as follows, Section 1 into Section 1.
Okay, Senator, are there any amendments?
There are none. End of bill.
Senator Wynn.
Thank you. Assembly Bill 114 revises the membership of the Nevada Early Childhood Advisory Council. The bill also defines the term early childhood program for purposes of the duties of the council as any program for children less than 8 years of age pertaining to nutrition, healthcare, mental and behavioral health, protection and play, and learning to stimulate the child's development. Additionally, this bill updates language pertaining to the representation of the tribal organizations within that same council.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 20, the noes are 0. AB 114 has received a constitutional majority, is declared passed, and ordered to the Assembly.
Assembly Bill 198, introduced by Assemblyman Ortlicker, revises provisions governing health care. The people of the state of Nevada, represented in Senate Assembly, do enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 17, end of subsection 2, end of bill. This bill requires a two-thirds majority vote.
Senator Daly.
Thank you, Mr. President. Assembly Bill 198 requires the State Board of Nursing to issue a certificate of registration as a certified registered nurse anesthetist to a registered nurse who meets the requirements of existing law and any additional requirements prescribed by the board. The board must adopt regulations governing such practitioners. The bill authorizes a certified registered nurse anesthetist working under the supervision of a physician licensed to practice medicine or osteopathic medicine in this state to order, prescribe, possess, and administer controlled substances, poisons, dangerous drugs, and devices to treat a person under the care of a licensed physician in a critical access hospital before, during, and after surgery or childbirth.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 19, the noes are 1. AB 198 has received a 2/3 vote, is declared passed and ordered to the Assembly.
Assembly Bill 218, introduced by Assemblywoman Considine, revises provisions governing landlords and tenants. People of the state of Nevada, represented in Senate Assembly, do enact as follows: Section 1, end of Section 1.
Are there any amendments?
There are none. Section 4, end of subsection 9, end of bill.
Senator Pazina.
Thank you, Mr. President. Assembly Bill 218 requires that in each place where a landlord lists the amount of rent due under a rental agreement and in any reference to the amount of rent due in a written rental agreement, the rent must be denoted as a single figure representing the total amount of the periodic rent that includes the amount of any fixed, mandatory fees to be charged to the tenant in addition to the base rent. A landlord is prohibited from charging a tenant an amount for periodic rent that exceeds the amount of rent due under the written rental agreement. The measure authorizes a tenant aggrieved by a violation of the provisions to bring a civil action in any court of competent jurisdiction and sets forth the remedies that a court must award to a tenant who prevails in such an action. The measure prohibits a landlord who allows a tenant to pay rent or any other fee or charge through an internet website or online portal from charging the tenant a fee to make a payment by these means in an amount that exceeds the amount of any fee charged by the operator of the internet website or online portal. Additionally, any such fee must be separately identified in a written rental agreement, and the bill is effective October 1, 2023.
Are there any remarks from the floor? Senator Stone.
Thank you, Mr. President. Colleagues, as a landlord for over 30 years, I like several provisions in this bill. In my portfolio of properties, my clients can pay their rent in person or through a dedicated mail slot on the properties that I own, or they can pay online 24/7 through their tenant portal, which is a part of the property management software that I subscribe to. The software I use allows a tenant to voluntarily pay by ACH for a $1.95 fee, which they, as a software company, charge the tenant, and I do not mark it up. This has saved my tenants a lot of late charges by paying online up until 12:59 p.m., the day before the rent is late, to avoid having to pay a 5% late fee in compliance with Nevada laws. Identifying the rent due each month as one total that summates all the tenants' fixed charges, such as trash, pet rent, etc., is transparent and it's fair. Tenants should always know what their total rent obligation is, and my tenants do. Any landlord that charges a tenant more than the agreed upon rent plus charges can already be sued under Nevada law. Providing a copy of a lease for a tenant to review is something that I already do if requested by the prospective tenant, and I'm sure most, if not all, landlords would do the same. What I oppose in this bill is the criminality and civil exposure to a landlord that simply may just make an error, which can be considered a deceptive trade practice. This is especially relevant for smaller landlords that don't have on-staff attorneys to review leases and can make mathematical errors or a software error and could be forced into insolvency with a large claim against them and having a criminal record. I know there have been decriminalization efforts in this legislature over the past few sessions, and here we're going to be criminalizing landlords. Most small landlords don't keep legal counsel on retainers because of their high expense. And by the way, the average landlord here owns 2.5 properties. We're talking about small landlords that own most of the portfolios in Nevada. Many of these small landlords are in fact senior citizens that live on this income, and a frivolous lawsuit can not only hurt them, but can destroy them financially. There should at least be, as a part of this legislation, a written warning that if a tenant is allegedly being charged more than their contractual rent, that they can request that the landlord simply fix the problem without a lawsuit, without criminality associated with it. And that problem should be able to be fixed expeditiously within 7 days. And if a landlord fails to correct this problem, then I'm in complete support of the legal remedies promoted in this bill. This legislature's worked hard to implement decriminalization reforms, yet here is a bill that seeks to criminalize landlords, and for those reasons, I strongly urge a no vote.
Any further remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 13, the noes are 7. AB 218 has received a constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 242, introduced by the Assembly Committee on Legislative Operations and Elections, revises provisions relating to elections. The people of the state of Nevada, represented in Senate Assembly, do enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 50, this act becomes effective on July 1, 2023, and a bill.
Senator Orenshaw.
Thank you, Mr. President. Assembly Bill 242 authorizes ballots or votes to be cast, registered, and recorded using a mechanical voting system and requires the use of a mechanical voting system for counting ballots or votes. The measure also revises the definition of mechanical voting system to include marking a mail ballot, which is subsequently counted by electronic means. Further, the measure requires each polling place with certain exceptions to provide at least 2 voting booths that are accessible for voters who are elderly or voters with disabilities. County and city clerks and election board officers must also be trained in using such accessible voting booths.
Are there any remarks from the floor? Senator Severs-Gansert.
Thank you, Mr. President. I'll be supporting Assembly Bill 242. We worked extensively with the Secretary of State to make sure that paper ballots are available and accessible. And so we had language that was added back in. So while this original bill eliminated paper ballots, I just want to be clear that those ballots are available. Thank you.
Any other remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 16, the noes are 4. AB 242 has received a constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 244, introduced by Assemblywoman Torres, establishes certain rights of persons compelled to submit to certain mental or physical examinations. The people of the state of Nevada, represented in Senate Assembly, do enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 3, this act becomes effective upon passage and approval, and a bill.
Senator Lang.
Thank you, Mr. President. Assembly Bill 244 sets forth rights of a person compelled to submit to a mental or physical examination. With certain exceptions, a person compelled to submit to such an examination pursuant to court order, a contractual obligation, or any other type of obligation has the right to receive an examination at least 21 days before the date of the examination, have an interpreter and certain observers present throughout the examination, take notes or appoint an observer to take notes during the examination, and after providing notice to the examiner, make certain recordings of the examination. The bill provides that testimony and reports of the examiner are not privileged communications. If the rights of a person compelled to submit a mental or physical examinations are violated, the person may bring an action in court to seek remedies. If notice of the violation is provided to the person who allegedly violated such rights no later than 7 days before the action is commenced. Finally, the bill repeals the provision of law authorizing an observer to be present at a mental or physical examination ordered by a court for purposes of discovery in civil action. Let me just give you a little bit of background information. In 2021, the Nevada Supreme Court held that the provision in law authorizing an observer to be present at a mental or physical examination ordered by the court for the purpose of discovery in a civil action is unconstitutional because it's, number one, a procedural statute that does not create a substantive right, and 2, it attempts to abrogate an existing rule of procedure that the court prescribed in its inherent authority to regulate the judicial process, and that was in Liff Inc. versus the 8th Judicial Court. This bill is effective upon passage and approval.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 16, the noes are 4. AB 244 has received a constitutional majority, is declared passed, and ordered to the Assembly.
Assembly Bill 340, introduced by Assemblywoman Summers Armstrong, etc., revises provisions governing certain actions and proceedings relating to real property. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1 into Section 1.
Are there any amendments?
There are none. Section 22 into Section 22 end of bill.
Senator Wynn.
Thank you, Mr. President. Assembly Bill 340 repeals, reenacts, reorganizes, and revises a provision for summary eviction of certain tenants who are guilty of unlawful detainer. The bill replaces repealed provisions of a new procedure for summary eviction, which applies to tenants who are not tenants of a commercial premises and who default in the payment of rent and who are guilty of unlawful detainer for reasons other than a default in the payment of rent. The bill provides that a landlord, upon the expiration of certain notice provided to the tenant, must apply by affidavit of complaint for the summary eviction of the tenant and serve the tenant with a file stamp copy of the affidavit of complaint and copy of the summons. If a landlord does not file with the court proof of service of the affidavit and summons within 30 days after the affidavit of complaint for summary eviction is filed, the court is required to dismiss the action for summary eviction. The tenant is required to file an answer to the affidavit of complaint within 10 calendar days after the date of service. If a tenant files an answer within the prescribed period, a hearing is held. If no such answer is filed, the court is authorized to order, without holding a hearing, the removal of the tenant within the prescribed period. The bill also requires a court that grants an action for summary eviction to automatically seal the eviction case court file under certain circumstances.
Are there any remarks from the floor? Senator Stone.
Thank you, Mr. President. A common theme this session is an obsession that all landlords are greedy, that optimize rent increases without consideration for their tenants' well-being, and will evict someone the minute one becomes late on their rent. For many smaller landlords like me, this is not the case. Many of us run a family business. If you look at the facts, individual landlords own 41.2% of all rental units. Landlords own 74.6% of 2 to 4 rental units, and 99% of landlords, 99%, own 1 to 4 unit properties. The average landlord rents to 2.5 households or 5.9 individuals, and 12.4 of individually owned rental units have belonged to the same landlord for 30 years or more. Landlords remodel or rehabilitate their units 17.6%, and according to the Pew Research Center, nearly half of individual landlords reported net losses on their properties. Average gross income of landlords is approximately $76,000, hence these small landlords are not the uber wealthy as they are stereotyped. You see, many landlords are not the big corporate giants that have to be financially responsible to shareholders for increasing their profits. Many are small businesses that spend many hours maintaining, upgrading, and managing their units. Many Nevadans that own 1 to 4 units with the average of 2.5 units, as was discussed. When a tenant does not pay their rent, in many cases, that means that 40% of their scheduled income is not coming in, yet they must still go through the eviction process after all attempts have failed at the high cost of including lost rent, and continue to pay their expenses, including property taxes, insurance, maintenance, including expensive HVAC fees, replacements, landscape fees, accountant fees, lawyer fees, etc. So by delaying the process to evict a tenant that is not paying rent can really hurt the small landlords that make up 41% of all rentals in Nevada. If you look at the present procedure for summary evictions, assuming that someone does not pay their rent on time, they're given a 4-day grace period by law. After 4 days, a landlord can order a 7-day notice to pay or quit, which can take about 8 or 10 days, advising the tenant of his or her right to contest the complaint, which can take a couple more days, and then the landlord can file a complaint with the court, which takes about another 3 days. The court holds a hearing and issues a judgment, which can take 3 days to a month, not to a month, 3 to 7 days, and then the order for removal is made, which usually averages 3 to 4 days. and then the landlord, after 3 more days, can have possession to the property. So it's a very optimistic timeline, but you can see that it can take basically more than 30 days if all the I's are dotted, the T's are crossed, and nobody is going to contest the eviction. But it's more likely a 45 to 60-day process if it's contested. That's under present law today. Meanwhile, a tenant can respond to the complaint and delay the process, contesting the complaint, and a hearing is then scheduled. The terms of renting a unit are outlined in a lease, which is a legal document in Nevada. Tenants and landlords sign on the dotted line that affirms their understanding of the terms and conditions of the lease, not limited to, but including eviction for non-payment of rent. Ignorance is not an excuse to not follow a legal contract, and remedies exist to protect all parties, whether you're the landlord or whether you're the tenant. Leases are no different. AB 340 repeals the process for summary eviction procedure in lieu of a new procedure, which significantly delays the process, increasing the cost for the landlord and ultimately the tenant. Because in most of the leases, if you have to go sue a tenant after they've been evicted for costs, that will be included, including, in most cases, legal fees and court costs. This will burden and overwhelm the courts with the unnecessary hearings. This new procedure could extend the evictions from 90 days to 100 days, 120 days or more, which creates harm for landlords, especially the small ones that I've mentioned. In addition, this bill would allow a delinquent tenant the right to file a civil action against the landlord for not following this new complex array of steps to regain access to their property. We all know that it's unlawful for a state government to pass an unfunded mandate on other governments, like local governments. Why then is it okay for this bill to pass an unfunded mandate on private businesses in the state? Of course, I understand the humanitarian elements of this bill. For the record, in being a landlord for over 30 years, I have never evicted one tenant, and I've always worked with my human clientele. Now, if the state wants to impose this draconian process on landlords to legally remove a tenant not paying their rent or violating terms of their lease, then the appropriate thing to do is to amend this bill and have the state pay for a reimbursement to landlords burdened by this legislation. The risk when passing this kind of legislation, picking winners and losers, is that many small landlords will just sell their units. And that's fewer units that will be available in our market that already has a significant shortage of residential units for rent or for lease. Property rights are a long-standing right in this nation and this state. The summary eviction process is fair to the landlord that is not receiving rent from a tenant and provides appropriate notice and time for a tenant to meet their legal obligations. A wise person once said, "The right thing with the wrong motive is the wrong thing." It's commendable that the author wants to do the right thing to give a delinquent tenant more time before they are evicted. But the wrong motive of this bill is to make the eviction process more difficult for landlords, which is just plain wrong. And for these reasons, I urge a no vote on AB 340.
Any further remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 13, the noes are 7. AB 340 has received a constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 350, introduced by the Assembly Committee on Judiciary, revises provisions governing forfeiture of property. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1 into Section 1.
Are there any amendments?
There are none. End of bill.
Senator Hansen.
Thank you, Mr. President. Assembly Bill 350 requires each law enforcement agency to include certain additional information related to seizures and forfeitures in the annual report submitted to the Office of the Attorney General. This bill additionally requires the Office of the Attorney General to make the reports relating to seizures and forfeitures that are published on its internet website available in a machine-readable format. Bill is effective October 1st, 2023. Off script a little bit, I think the whole asset forfeiture issue needs to be seriously investigated by future legislative bodies, and I think this will help establish some of the base data we need to make good decisions on this one. So I would urge a yes vote on AB 350. Thank you, Mr. President.
Any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 20, the noes are 0. AB 350 has received the constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 398, introduced by the Assembly Committee on Commerce and Labor, makes various changes relating to insurance. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1 into Section 1.
Are there any amendments?
There are none. Section 2 into Section 2 into bill.
Senator Lang.
Thank you, Mr. President. Assembly Bill 398 prohibits an insurer from issuing or renewing a liability insurance policy that contains a provision that, 1, reduces the limit of liability stated in the policy by the cost of defense, legal costs, and fees and other expenses for claims, or 2, otherwise limits the availability of insurance for the cost of defense, legal costs, and fees and other expenses. The mandatory provisions of these bills do not apply to any contract for liability insurance existing on October 1, 2023, but apply to any renewal of such a contract. The bill is effective on October 1, 2023.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 19, the noes are 1. AB 398 has received a constitutional majority, is declared passed and ordered to the Assembly.
That concludes Order of Business 13 on the first agenda.
Order of Business 16, remarks from the floor, introduction of guests. Senator Donate.
Thank you, Mr. President. I do have with me a guest in the gallery. His name's Braden. Braden, if you could stand up. Hopefully he's up there. There you go. So for those of you who haven't had the chance to meet Braden yet, he is here from the University of Pittsburgh. He is a political science and psychology major. He's also the awardee for the Obama-Chesky Voyager Scholarship Program for public service. And for those of us who don't know, the Voyager Scholarship was created by the Obamas and Brian Chesky, who is the founder of Airbnb. And it helps shape leaders who can bridge divides and help solve the biggest challenges together. The students who are accepted to this program receive a $50,000 scholarship for tuition assistance, and they also receive $10,000 to travel the country for their project. Braden's project is actually, he plans to study electoral politics, specifically on why people vote the way they do, and he hopes to, if many of my colleagues have the opportunity to speak with him, he's here to learn about state-level politics and how legislators view their jobs and why we got elected. And so please join me in welcoming him to the Nevada Legislature.
Senator Flores.
Thank you, Mr. President. Also joining me in the gallery is Frank Perez and his amazing son, Mariano Perez. I don't know if they're standing back there. I just saw him earlier today, but he used to be my attaché both in 2017 and 19, and I had the privilege of seeing his amazing son born and raising him into an amazing young man. He's a very good friend of mine. He does a lot of amazing work in the city of Reno, but more importantly, he's just a great community leader. So if you could give them a quick round of applause.
Before we continue with remarks on the floor, the following bills are ready to be immediately transmitted to the Assembly. Assembly Bills 39, 49, 57, 65, 114, 198, 218, 242, 244, 340. Once these bills have been transmitted to the Assembly, the Senate no longer has the ability to take any further action. Any remarks or objections? Okay, we'll continue on with remarks from the floor. Senator Canizaro.
Thank you, Mr. President. I move that we stand in that the Senate stand in recess until the call of the chair.
Okay, we are in recess.